Go ahead and start. I'm Susan Marvin, Director of the Florida Dispute Resolution Center, and I'm pleased to have you join me at the Mediator Ethics Plenary this afternoon. And this is the last event in the 2017 conference, and we have really enjoyed having you here. This year, you're going to be observing a panel hearing involving a grievance filed against a Florida Supreme Court certified family law mediator in a mock mediator qualifications and discipline review board case. The board is tasked by the Florida Supreme Court with disciplining Florida Supreme Court certified and court-appointed mediators. The procedures for disciplinary hearings are in Part 3 of the rules, as we hope you know. Rule 10.820 pertains to hearing panel procedures, and Rule 10.830A provides that the prosecution must prove its case by clear and convincing evidence. Due to time constraints today, so that you may leave on time, the mock proceeding you will see today is an abbreviated one, which will include an opening statement and a brief presentation of witnesses by each of the two attorneys, with cross-examination of the witnesses, but no closing statements by the attorneys as we would usually have in a real hearing panel proceeding. You will be seeing a hearing panel deliberation today, so that's an important part of the proceeding, and that will be abbreviated too, but you will get a taste of what that is like. Our hearing panel is comprised of actual MQDRB members, and we really appreciate their volunteering for this task. Farthest away from me is Kimberly Mann, and then Vivian Perez, and Valerie Kiffin-Lewis, and Forrest Young, and the Honorable Judge John Jordan. Those are our volunteers for the panel. And we also have Grant Slayden as the mediator, William Short, Juan Collins, the DRC staff attorney, as Tyrone Billings, the mediator's attorney for the hearing, Melvia Green, is the MQDRB prosecutor today, Stephen Leigh as the complainant, John Murray, and Stephanie McCarty as Charlotte Merlot, the attorney for one of the parties, Lily Magic.
Good afternoon, everyone. My name is Kimberly, and I have stepped to the podium to tell you that at the front part of your tables, you all have a handy handout. So if you haven't seen that yet, if those of you closest to the front of the table could reach around, you have some script materials, you have a cast of characters, you have the complaint that has been filed by the party, John Murray, you have a response from the mediator, William Short. You have a copy of the investigative report that was done, as well as the formal charges that led to this panel proceeding. And last but not least, the very last page, you have an opportunity to deliberate along with the panel and list out toward the end of the session any sanctions that you think were appropriate for the mediator in this particular situation. And with that, I will turn it over to our cast of characters.
All right, Ms. Green, are you ready to present your case?
I am, Judge.
Please call your first witness, and all the witnesses have been previously sworn in.
Okay. I'll start with my opening.
Thank you.
Good afternoon to the members of the Mediator Qualifications Discipline Review Board, Mr. Billings and Mr. Short. My name is Melvia B. Green, and it is my pleasure to serve as the prosecutor on behalf of the board in its complaint against Mr. William Short. It is the board's position in this proceeding that the evidence will be clear and convincing that the Florida Supreme Court certified family mediator, Mr. William Short, violated the following Florida rules for certified and court-appointed mediators. Number one, Rule 10.310 A and B, self-determination, coercion, prohibited. Number 2, Rule 10.340 D, conflict of interest. Number 3, Rule 10.350, demeanor, conflict during mediation. And number 4, Rule 10.380 C, fees and expenses, written explanation of fees. Specifically, the evidence in this proceeding will show that the complainant, Mr. John Murray, and his former spouse had a dispute involving a change in child support payments in the 21st Judicial Circuit in and for Adams County, Florida. The trial court on its own issued an order referring this dispute to private family mediation. This order provided, among other things, that within 10 days, the parties were to submit a stipulation with order as to the designation of the mediator to the judge, and that the parties were to each pay the mediator $200 per hour for a total of $400 per hour. In the event the parties were unable to agree to a mediator, the order further provided that the court would appoint the mediator. Thereafter, the court appointed Mr. Short to serve as the mediator to this dispute. The evidence will show that after his appointment, Mr. Short never supplied the parties or their respective counsel with any written explanation of his fees for the subject mediation as is required by Rule 10.380C. The evidence will further show that although the mediation had been scheduled for 3 hours, that is from 2:00 p.m. until 5:00 p.m., for one issue, the mediator, sua sponte, unduly prolonged this mediation for 5 hours by initiating discussions about matters other than the child support modification issue. In so doing, the mediator unduly prolonged this mediation to justify additional compensation, and in so doing created a conflict of interest with the parties in violation of Rule 10.340D. At approximately 5:30 p.m., the complainant, Mr. Murray, will tell you that he had had enough and wanted to leave the mediation. Mr. Murray will further tell you, however, that the mediator stated that, quote, unless Mr. Murray remained at this mediation and paid the money, Mr. Murray would be held in contempt of court and possibly go to jail, close quote. Mr. Murray will further testify that his then attorney advised him to just pay the fee, sign the form, and be done with this. Mr. Murray thereafter complied. Mr. Murray will tell you that he executed the settlement agreement against his will and because he felt threatened. It is the board's position that the mediator's statement to Mr. Murray amounted to prohibited coercion and violated his right to self-determination in violation of Rule 10.310A and B. You will also hear testimony that during the course of this mediation, the mediator exemplified rude and disrespectful behavior in violation of Rule 10.350. Specifically, Mr. Murray will testify that he overheard the mediator talking on his cell phone in the hallway stating, "I'll be home after I get rid of these eccentrics," a reference to which Mr. Murray states was to him and his former spouse. Mr. Murray will further testify that during the mediation, he overheard the mediator laughing a lot with his former spouse and her attorney during their private caucuses, but never expressed such joviality with him and his attorney during private caucus. Finally, you will hear evidence that as the participants were leaving the mediation, the mediator gave each of them the mediator's real estate business cards and told them that he could get them deals on vacation rentals. In so doing, the board submits that the mediator violated Rule 10.340D by seeking to provide a service that was not directly related to the mediation process. After you've heard and considered all of the evidence, it is requested that you find, by clear and convincing evidence, that the mediator has violated the Florida rules for certified and court-appointed mediators as charged, and that you impose the appropriate disciplinary sanctions. Thank you.
Mr. Billings, you're going to reserve, or would you like to do your opening now?
I'll do it now.
All right.
May it please the panel. Good afternoon, panel members. My name is Tyrone Billings, and I am representing Mr. William Short in the matter before you today. Mr. Short conducted a mediation on January 15th in which the complainant and his ex-wife, Ms. Leigh Magic, were the parties. Mr. Short adamantly disputes the claims made by Mr. Murray in his complaint and asserts that he conducted the mediation in question with the highest of professionalism in accordance with the Florida rules for certified and court-appointed mediators. Mr. Short is a well-known and respected mediator in the mediation community, and Mr. Short has earned that respect from his peers and others in the mediation community because of his professionalism and outstanding mediation skills. The record in this case will reflect that in the mediation at issue, the complainant, Mr. Murray, was represented by counsel, Mr. Evan Huff. In regards to the specifics of the complaint, the mediation was scheduled for 3 hours, which is the normal time allotted for these cases, and it went on for an additional 2 hours, and again, which is not unusual. All parties worked diligently to resolve the issues, and at no time did Mr. Murray or his attorney, Mr. Huff, express any desire to end the mediation to Mr. Short. If Mr. Murray had expressed such desire to his attorney, it was not relayed to Mr. Short. The mediation process was explained during the opening statement, and both parties was advised that they could terminate the mediation by impasse or adjournment at any time. In an additional 2 hours, the parties did reach an agreement, and both parties signed the agreement. In regards to the additional fees, as I just stated, the parties had not reached an agreement at the time allotted, and the mediation went on for an additional 2 hours. The parties were charged for the additional 2 hours at the rate specified in the court's referral to mediation. My client did not send the complainant a fee schedule because it would have been redundant, as the fees and the share was determined by the court and thus explained in the court's order to mediation. Rule 10.380 requires that the mediator give the parties an explanation of the cost and fees. Paragraph 1 of the rules explains the basis for the amount of the charges. Well, the basis for the amount of the charges was in the court order, and the amount was spelled out in the court order. Paragraph 2 of the rules states the amount charged if there is a cancellation or postponement. There was no cost associated with cancellation or postponement because the court order did not authorize any such charge. Paragraph 3 of the rules states the basis for additional charges. Again, there were no additional charges because the court did not authorize any additional charges. And finally, paragraph 4 of the rule states the parties' pro rata share. And again, the pro rata share was spelled out in the court's order to mediation. Thus, my client had no additional information to provide to the complainant outside what had been provided by the court. My client believes that the purpose of the rule is to inform the parties of the cost of mediation and their respective share of the cost. And this information was provided to the complainant by the court in this order to mediation. With regards to Mr. Short giving the parties his business cards, Mr. Short does admit that he'd offered his business cards to the parties after mediation, after the session had ended and the agreement had been signed by both parties. What Mr. Short has learned through his years of mediating is that mediation can be hard on the parties and their relationships, even when the parties reach an agreement during a mediation session. In such cases, the parties still have to try to maintain or salvage some type of relationship. Mr. Short will often try to say something or do something or bring light to the situation, especially at the end of the session, so the parties can leave on a good note. In offering his business card, Mr. Short was trying to be cordial and lighten up the atmosphere of the parties, to bring up vacations, etc., to get the parties to think about something enjoyable and that everyone sees it in a positive light. So he mentioned vacation in that sense. Mr. Short thought this might improve the moods of the party and in no way expected or perceived it in a negative light, and he certainly apologizes if it was taken in any other way. My client denies making any disparaging remarks about the complainant during mediation or at any time for that matter. With regards to Mr. Murray stating that he could hear Mr. Short and other parties laughing through the walls, Mr. Short reiterates that he knows how hard the mediation sessions can be on the parties, and if he sees the opportunity to make the parties feel at ease, he reacts to that opportunity. Mr. Short remembers Ms. Magic and her attorney being jovial and approachable, while Mr. Murray and Mr. Huff seems at odds with each other, very somber and not amenable to him in interjecting himself to lighten up the atmosphere. Mr. Short certainly did not act in any way to be disrespectful, and again has been recognized by his peers for his professionalism and mediation skills and this type of approach to mediation. As noted in the complaint, Mr. Murray has a new attorney. Mr. Murray was apparently unhappy with the legal representation rendered by Mr. Huff on the day of the mediation, and it's apparent that he's unhappy with the agreement he signed with Mr. Huff's advice. Mr. Murray has stated that he would withdraw his complaint if Mr. Short goes to court and testifies to what occurred during the mediation session so that he can get this arrangement thrown out. My client advised Mr. Murray in the opening statement at mediation that in accordance with the Florida rules for certified and court-appointed mediators, all communications revealed during mediation are confidential, and that even a judge won't know what's said during mediation. So Mr. Murray has basically asked Mr. Short to break the rules of confidentiality or be subject to this complaint. His intent is clearly stated in his complaint, and I would hope that the panel sees this for what it's worth. Mr. Murray's concerns are not with the mediation session, but with an agreement he signed with his attorney's advice, something that Mr. Short had no control over. Once again, Mr. Short conducted a mediation session on January 15, 2017, with the highest of professional standards, and did not do anything or say anything that was unprofessional or inappropriate. Mr. Short thanks you, and I thank each of you for your time and indulgence.
All right, thank you, Mr. Billings. Ms. Green, you may proceed.
Thank you, Your Honor. I would first call Mr. John Murray to the stand, and you've been previously sworn.
Should be on.
Good afternoon, sir. Would you state your name for the record?
Yes, my name is John Murray.
And Mr. Murray, I call your attention to a January 15, 2017 mediation between you and your former spouse over the modification of your child support payments. Do you recall that mediation?
Yes, I do.
Did you and/or your former spouse request this mediation, or was it ordered by the judge?
Neither Lily nor myself requested that mediation. It was ordered by the judge.
And who was the mediator selected for this matter?
His name was William Short.
And can you identify Mr. Short for the record?
Sitting back there.
Okay, the record will so reflect. And did you and/or your former spouse, were you represented by counsel at this mediation?
Yes, I was.
And by whom?
His name was Mr. Evan Huff.
And was your former spouse represented at this mediation as well?
Yes, she was.
And by whom?
Ms. Charlotte Merlot.
Okay, Mr. Murray, I'm going to show you an order of referral to the private mediation. I ask you to take a look at it. Now, did you ever see that prior to this mediation?
Yes, ma'am, I did.
Okay. And prior to this mediation, did you ever receive any documentation from the mediator as to any explanation of his billing practices for this case?
No, I did not.
Do you know whether or not your lawyer received any such documentation?
That I don't know.
Okay. What was your understanding as to the length of this mediation?
Mediation was set for 3 hours. It was supposed to be from 2 o'clock until 5 o'clock.
And what was your understanding as to your payment for the cost of this mediation?
I was responsible for one half. The mediation cost was going to be about $1,200, so I was responsible for $600.
And who told you this?
My attorney.
Okay. How much did you pay for this mediation?
$1,000.
And did the mediator request an additional payment?
Yes, he did.
And did he say why?
Well, because the session went 2 hours over the scheduled 3 hours.
Now, how long had this mediation been scheduled for?
3 hours initially,
And in fact, how long did it last?
5 hours.
Did you or your attorney request the mediation be extended?
No, we did not.
Okay. During this 5-hour mediation, were you and the other participants given the opportunity to take a break for food?
No, not the entire time.
Now, in your sworn complaint to the DRC, you have stated that you wanted to leave the mediation at 5:30, but was not permitted to do so. Is that correct?
Yes, it is.
Who told you that you could not leave?
William Short told me that.
And why did he say you could not leave the mediation?
Well, he said to me that if I left the mediation, I would be held in contempt of court, and then I could go to jail. I didn't want that to happen.
Well, was your attorney present when the mediation said this?
Yes, he was.
And what did you do and why?
Well, I just did what my attorney told me. I paid the fee and signed the form, and, we had to get this over with.
Did your attorney tell you to do this?
Yes, he did.
Is this what you wanted to do?
Oh, absolutely not.
Now, you've also averred in your sworn statement that the mediator was disrespectful and discourteous during this mediation. Please tell the board how the mediator was discourteous and disrespectful during the mediation.
Well, the mediator really was disrespectful. He was discourteous to me. He spent a fair amount of time with the other side where he had left my attorney and myself alone for upwards of an hour. We were just sitting in the room by ourselves. We finally started playing Uno. He was really, I could hear him laughing with the other parties in the other room while we were separated. And to be quite honest with you, to add insult to injury, I heard him call both Lily and myself eccentrics.
Now, did you and your former spouse ultimately reach a settlement during this mediation?
Well, if you want to call it that, yes.
Okay, did you sign the settlement agreement?
I had to.
Well, you didn't want to?
I did not want to.
Why not?
Well, the agreement, the whole idea of the mediation was really to go over a modification for child support. The mediator kept bringing in other things, but really, I don't think that we did what we needed to do in the mediation as far as child support was concerned. So I signed it based on what my attorney told me and based on the fact that the mediator said I would be held in contempt of court and could go to jail.
Are you currently seeking to have the mediated settlement agreement set aside?
Yes, I am.
Please explain why.
Well, basically, I felt as though I was coerced, that I didn't really have the freedom to say no based on the things that I've mentioned before. And the mediator was, I didn't think he was being fair.
At any time during the mediation, did the mediator ever give you and the other participants any business cards?
Yes, he did.
Now, when did he give that to you, and what type of business card did he give you?
Well, it's right around 7 o'clock at the end of the mediation. He gave us a business card. Apparently, he's some sort of realtor.
And what, if anything, did the mediator say to you when he gave you these cards?
He told all of us that he would get us a great deal on a vacation package.
Did you say anything to the mediator as a result?
No, I did not.
Did your attorney say anything to him as a result of that statement?
Incredibly, yes. My attorney said that he would talk to him about it later. Unbelievable.
Okay, thank you. No further questions.
Mr. Billings?
Good afternoon, Mr. Murray.
Good afternoon.
Mr. Murray, if you don't mind, I'd like to ask you some questions relevant to the complaint you made. My first question, Mr. Murray, is were you represented by counsel at the mediation that occurred on January 15th, 2017?
Yes, I was.
Is that attorney with you today?
No, he's not.
Mr. Murray, my second question relates to the time of the mediation. You said it was originally scheduled for 3 hours and it was extended for 2 hours?
That's correct.
Okay. You also mentioned you had an issue with the mediator bringing up additional items. Were you in caucus most of the mediation? In other words, were you all mostly separated, you and your ex-wife?
Pretty much we were, yes.
So you don't know what questions or concerns Ms. Magic was raising with Mr. Short in caucus, do you?
How would I know? I wasn't in the room.
Thank you. Now let me ask you this. At 5 o'clock, when the mediation was scheduled to end, had you all reached an agreement?
No, we had not.
And is it okay if I surmise that since it went on for 2 more hours, that you probably were still far apart at 5 o'clock?
Honestly, I don't know how far apart we were because I don't really know what Lily and her attorney were talking about, but we had not come to an agreement.
Okay, now you said that the mediator, I heard you say twice, you said would and could. You said that the mediator told you that you would go to jail, and another time he said that you could go to jail. So can you clarify that for the panel?
Yes. The mediator said that I could be held in contempt of court, and that if I had been held in contempt of court, I would go to jail. So it was always kind of looming out there.
Did you come to the mediation in an attempt to reach an agreement on that day?
Yes, I wanted to have child support modified.
Now let's move to the fee issue. Did you ever see the order for a referral to mediation?
Well, I did see it. My attorney shared it with me, yes.
And did he discuss with you in the order the referral and the fees that you would pay?
Yes, he did.
Did the order say that each party would pay $200 per hour?
Yes.
And did the order also say that each party would pay half
Yes.
of the mediation fee? And so you were charged $200 an hour for the mediation, is that correct?
Well, I was charged $200 an hour for the first 3 hours, but then we had 2 more hours, which that was never discussed with me.
And were you charged $200 for those additional hours?
Yes, I certainly was.
And do you know if Ms. Magic was charged the same amount?
Honestly, I don't know if she was charged. I know I was.
So, but you are saying that everything that you were charged was in the order of referral. You were charged $200 an hour, and you were charged half of the mediation fees.
Well, not really. I mean, the fees were listed there, but that order didn't say a thing about if the mediation went beyond the 3 hours. It didn't say that at all.
But were you charged anything beyond $200 an hour
For the
for the additional 2 hours?
No, I was not.
Okay. And let's talk about the conversation you indicated you overheard about the laughing, and about the laughing you heard through the walls. First, let's take the conversation you stated you overheard. Mr. Short say, I'll be home after I get rid of these eccentrics. Did you hear Mr. Short state your name or Mrs. Magic's name?
I don't think he had to. We were the only people there. So he's talking about Lily and me.
Okay, help me understand why you assume that Mr. Short was talking about you. Have you ever been described as eccentric before?
Only by Lily. No. I haven't.
Now, we'll get to this a little later, but I assume you know that Mr. Short sells real estate because you mentioned that he gave out a card. If I were to tell you that after mediation, which was scheduled to go until 5 o'clock, that Mr. Short had to meet with 2 real estate clients, and let's say they wanted some strange modifications to their home, so he was on the phone talking to his wife, and he said he'd be home after meeting with the 2 real estate clients. Would you have any reason to dispute that?
I guess I wouldn't have any reason to dispute it at the time if it was after the mediation, but this was during the mediation. And, I didn't know that he was a realtor, not until the end of the mediation session.
Okay. Now, on the laughing matter, now we discussed that you were represented by Mr. Huff, and we mentioned the fact that he's not here. Is it safe to say that you were not happy with the services provided by Mr. Huff at the mediation?
Yes, it is safe to say that.
Now, in your complaint, you say that you told Mr. Huff you wanted to end the mediation, and obviously it didn't end at the time. You also stated that you didn't want to sign the agreement, and again, obviously you signed that. So not only were you unhappy with Mr. Huff's services on that day, But you also are unhappy with Mr. Huff's performance today as well, right? The fact that he's no longer representing you?
Well, I didn't really want him here. I have a new attorney, but I was not happy with Mr. Huff.
And so you weren't happy with him on the day of mediation, and do you think the mediator picked up on that during your caucus section?
I really don't know what the mediator picked up on. We didn't spend a lot of time together.
Now, as reflected in your unhappiness, these sessions can be tiresome, mentally draining, and downright offensive. And Mr. Short does his best to make clients and parties feel as comfortable as possible, and even try to get a laugh out of the parties. So did you hear Mr. Short say anything that was inappropriate when you heard the laughing and talking through the walls?
Well, no, I didn't hear anything inappropriate. I just heard the laughing. But I got to tell you, he spent a lot more time with Lily and Miss Merlot than he did with me and my attorney, and he certainly wasn't trying to make us feel that happy or comfortable with the session.
Okay. Mr. Murray, you also stated in your complaint that Mr. Short gave out his business cards to everyone. Is that correct?
Yes, he did.
And he gave them to everyone?
Yes, he did.
You also said, quote, as we were leaving the mediation. So isn't it true that the mediation was over?
Yes, it was over.
Isn't it also true that an agreement had been reached and signed by both parties?
Okay, yeah. If you want to call it that, we did sign the agreement. Yeah.
Did he ask you or anyone in reference to giving you the card to do anything? Was there any kind of favor acts in exchange for giving you the card?
Well, I kind of took it like if we took his card and then we availed ourselves of his services, which is what he was suggesting, that we'd get a great deal on a vacation rental. So it was kind of like, give me the business and I'll give you a great deal.
Okay, and didn't your attorney, Mr. Huff, tell Mr. Short thank you and that he would be in touch?
Yeah, he said that.
Now let's talk about the agreement. You don't like the agreement, is that correct?
That's correct. I don't like the agreement.
But you signed the agreement at Mr. Huff's advice, is that correct?
That is correct.
And he was your legal counsel at the time, is that correct?
He was my attorney. Whether or not he was my legal counsel is in question at this point.
Okay, do you remember during his opening statement that Mr. Short said that mediation is a voluntary process?
Yeah. We were ordered to mediation by the judge, but okay.
Okay, do you remember him also
All right,
saying?
counsel, I think you're getting a little duplicative here. Is there any final questions you want to ask this witness? We need to move on.
Yes, I guess the final question, Your Honor, would be, did you indicate to Mr. Short that you would withdraw this complaint if he would testify before the judge to help you get your mediated agreement thrown out?
Yes, I did. If he just admitted that he was unprofessional, if we could just get the agreement set aside, and if he would give me my money back, I would withdraw.
Okay, I just have one more question. So you're saying that...
Okay, Mr. Colombo, go ahead.
So you're saying that you don't have a problem with the mediator, but it's really the mediated agreement that you have the problem with?
I had a problem with the mediator. I had a problem with the mediation, and I had a problem with the agreement.
And you had a problem with your attorney?
Yes, I did.
I have no further questions.
All right, thank you. All right, you can step down. Call your next witness.
Okay, I would call Ms. Charlotte Merlot to the stand. You've previously been sworn. Good afternoon, and would you state your name for the record?
Charlotte Merlot.
And Ms. Merlot, what is your occupation?
I'm an attorney,
And how long have you been an attorney?
13 years.
Now, I call your attention to a January 15, 2017 mediation between Mr. John Murray and his former spouse over a modification of child support. Were you present?
Yes, I was.
Do you recognize the mediator here today?
Yes.
And can you identify him for the record?
William Short.
And the record will so reflect. Now, you represented Mr. Murray's former spouse at this mediation, did you not?
I did.
And Mr. Short was appointed as the mediator by the court rather than by you and opposing counsel, correct?
Correct?
Now, prior to the mediation, Mr. Short never provided you with any documentation as to his mediation billing practices, did he?
He did not.
Now, was it your understanding that this mediation was scheduled for only 3 hours?
Yes.
Now, this mediation, however, lasted 5 hours. That is from 2 to 7 p.m., is it correct?
Correct?
Now, during this time, the parties were never given the opportunity to take any food breaks, were they?
They were not.
Now, this entire mediation was conducted by private caucus with the parties, correct?
Yes.
Did you ever overhear the mediator on the phone while in the hallway?
I did not.
Would you characterize the mediator as generally jovial while in the private caucus with you and your client?
He was professional.
Now, you and your client were satisfied with the mediated settlement agreement, correct?
Miss Magic was satisfied, yes.
Now, as you are aware, Mr. Murray is currently seeking to have that mediated settlement agreement set aside. Is that correct?
Correct?
Now, you and your client are upset with Mr. Murray about his efforts to have that mediated settlement agreement set aside, correct?
Miss Magic is upset, yes.
And as everyone was leaving this mediation, now the mediator handed you all out his realtor business cards, did he not?
He did?
The mediator also offered all of you discounts on future vacation rentals, didn't he?
He did?
How did you feel about that?
Thought it was kind of tacky.
Now, Ms. Merlot, I hate to interrupt the testimony. I'd like you to treat that microphone like a fine glass of wine. Put it a little closer to your lips so
Merlot,
everybody can
okay.
hear you. Go ahead, Ms. Green.
Again, tell us how you felt about the mediator's offer to give you deals on vacation rentals.
I thought it was kind of tacky.
You thought it was tacky?
I did?
Nevertheless, did you wonder what kind of deal he could offer you?
Oh, yeah.
No further questions.
Have a seat, Ms. Merlot. I think Mr. Billings may have a question or two for you.
Yes, I've got a couple of questions. Is it your testimony today, Mrs. Merlot, that you represented Ms. Magic at the mediation on January 15th?
It is?
Can you tell the panel from your perspective how the mediation went that day?
We were satisfied with the way the mediation went.
Did you or your party have any concerns about the mediation?
We did not?
Were you ever told that the other party objected to continuing the mediations?
I was not told.
And was your client happy that the mediation continued and that you all reached an agreement?
Yes.
Did your client relate to you how she felt about how the mediation went?
She was also satisfied.
One last question. Mr. Murray stated that he heard you and your client and Mr. Short laughing through the walls while you were in caucus. Did you ever hear Mr. Short say anything inappropriate while you all were in caucus?
I did not.
Thank you, Ms. Merlot. I have no further questions.
Ms. Green, any other witnesses? All right, so Mr. Billings, if you'd call your first witness.
Yes, Your Honor, I'd like to call Mr. Short.
Thank you, sir.
Okay, the witness has been sworn. Good afternoon, Mr. Short. Will you state your full name for the record?
Yes, it's William Bill Short.
And what is your occupation?
I am a Supreme Court certified family mediator.
And how long have you been a mediator?
Approximately 10 years.
Okay. And approximately how many mediations have you conducted?
Oh, golly. I'd say probably 1,200 mediations.
And did you conduct a mediation on January 15, 2017?
Yes, I did.
And were Mrs. Murray and Mrs. Magic, Mr. Murray and Mrs. Magic, the parties? at that
Absolutely.
mediation?
They were there for the mediation with their attorneys.
Do you remember anything unusual about that mediation?
I remember that particular mediation ran long, and that's because we were getting close to a settlement, and I have a very high settlement rate, so I wanted to make sure that we got a settlement in this particular case. Plus, it was a very difficult case, so I wanted to make sure that we completed that.
And was Mr. Murray represented by counsel?
Yes, he was, Mr. Huff.
And was The mediation primarily in caucus, and you primarily communicated with Mr. Huff?
Absolutely. I could tell the parties weren't happy, and so I thought it best to go immediately into caucus and keep them in caucus throughout the mediation.
Did Mr. Huff ever express any displeasure about anything that occurred during that mediation?
Mr. Huff did not. I primarily dealt with the attorneys during the mediation, not the parties, and they didn't express any displeasure. In fact, one of the parties wanted to continue very vehemently.
And as mentioned, going over continuing, the mediation went 2 hours past the scheduled time. Is that unusual?
No, mediations sometimes are shorter, sometimes they're longer. It really depends on each particular mediation, the needs of the parties.
Did Mr. Huff ever express to you that his client wanted to declare an impasse or end the mediation session?
No, he never did.
And who set the fees for this mediation?
The fees were set by order of the circuit judge. It was very explicit in the judge's order how much I could charge.
And who set the share for the parties?
That was also in the judge's order.
Now, Mr. Murray alleges that you didn't provide him a fee statement outlining the fees, cost per hour, pro rata share. Weren't all those things discussed in the order of referral to mediation?
They absolutely are. I didn't see it was my place to try to expound upon or change the judge's order.
Okay, Mr. Murray also alleges that he heard you talking on the phone in the hallway about him and Mrs. Magic. Did you ever make any disparaging comments about either of those parties on the phone or off the phone, for that matter?
I absolutely did not. At one point, I did make a phone call outside. I was calling my wife because the mediation was going to go long, and I had to let her know that I was going to be late for dinner because I had another appointment immediately after the mediation, and so I had to make sure she could delay that and then go deal with some people that were giving me trouble on a closing of a house.
Thank you. Mr. Murray also alleges that he heard you and the other parties laughing when you were in caucus. Isn't that often your style in mediation, that you try to make the parties feel at ease, have something positive to say, and sometimes it may be jovial to the parties?
Yeah, absolutely. You know, a mediation sometimes, especially in the family area, is very fraught with anxiety and bad feelings, and so I try to make everyone sort of be relaxed and at ease. I took a course at the recent DRC conference where they talked about lateral thinking and positive outcomes, and I always try to couch things in those terms.
Did you ever say anything inappropriate or disrespectful to Miss Magic or Miss Merlot while you were in caucus?
Absolutely not. I was always appropriate and professional.
Now, Mr. Murray also alleges that you brought up additional issues in the mediation. Did you personally create or bring up any additional issue in the mediation session?
Absolutely not. My goal was to finish the mediation, not make it harder. I only brought issues to the table that were raised by the parties in caucus.
Did the parties reach an agreement?
They certainly did. They reached an agreement and signed the mediated settlement that evening.
Did you threaten, force, or coerce Mr. Murray into signing that agreement?
Absolutely not.
And you testified that you primarily spoke to Mr. Huff during the caucus session. Did Mr. Huff ever express any reluctance of having his client sign that agreement?
No, he did not.
I have no further questions from this witness.
Ms. Green?
Good afternoon, Mr. Short. You are a Florida Supreme Court certified family mediator, is that correct?
Yes, ma'am.
And you were a Florida Supreme Court certified family mediator during the mediation between the complainant, John Murray, and his former spouse on January 15, 2017, is that correct?
Yes, ma'am.
And you were appointed as the mediator by the trial court, were you not?
Yes, I was, by a circuit court order.
Now, after your appointment, you never provided the parties or their counsel with any written explanation of your fees and billing practices, correct?
I did not, because it was all contained in the order, I thought.
You thought? Well, for example, if one or any of those parties had decided not to show up at your mediation without explanation, do you think you would have been entitled to a cancellation fee from the court?
I don't think so, because it wasn't in the order.
The parties absolutely had no knowledge of your billing practices, correct?
Well, from the order, they knew it was going to be $200 each per hour, and they were splitting it 50-50. That was all contained in the judge's order.
But that's all they knew, right?
Well, just the information was in the judge's order, correct.
Now, this mediation was scheduled for 3 hours, correct?
Well, I scheduled it for 3 hours. I thought it would take that long to do a typical mediation.
There was nothing in that notice that the mediation would last longer than those scheduled 3 hours, was there?
Not that I recall.
Okay. The sole issue at this mediation was a change in child support payments, correct?
Yes, that was the issue that was referred to mediation.
Now, the mediation, in fact, lasted 5 hours,
Well, it did, yes, it did.
and there were no food breaks, correct?
Well, we were getting close, I thought, and I wanted just to continue on and finish it for the party's benefit.
Okay. Now, Mr. Murray never asked to extend this mediation, did he?
I can't recall if, Mr. Huff I dealt with primarily, I can't recall if he requested to extend it, but he certainly didn't object when I told him that the other party, Ms. Merlot, wanted to extend it.
You ultimately collected an additional $400 per party for the extra 2 hours, correct?
Yes, I did, but I did the work. I was entitled to the compensation.
Now, during this mediation, issues other than the change in child support payments were discussed with the parties, were they not?
Well, the Ms. Merlot, on behalf of the other party, did bring up other issues that were in the dissolution case.
Now, the complainant, Mr. Murray, wanted to leave the mediation by 5:30, didn't he?
I'm not sure. Mr. Huff, his attorney, never told me that they wanted to leave. I told them that we needed to stay longer, and they had a discussion, and then they stayed.
Well, now, didn't you tell Mr. Murray that unless he stayed and paid the money, he would be held in contempt of court and possibly go to jail?
Well, I certainly didn't say he would be held in contempt of court. A technique I use often is to ask the attorney, what could happen if the parties don't participate in a process or do something in a process. And the attorney might have said he could have been held in contempt. I don't recall exactly.
Now, shortly thereafter, Mr. Murray signed the settlement agreement, did he not?
He did. He signed it that night willingly. And
Now, during the mediation, did you have a private phone conversation in the hallway?
yes, I did. I did step out, and that's only because the mediation was going long. And I wanted to make sure my wife knew I'd be home late for dinner because I had another appointment immediately after the mediation.
Did you also state that you would be home after you got rid of these eccentrics?
I said something similar to that, but I was talking about the parties that were involved in the closing of my house. They've been very difficult to deal with.
Now, as the parties were leaving the mediation, you supplied each participant with your real estate business cards, did you not?
Well, I certainly did. We had signed the agreement at that point. We'd left the mediation rooms. We were walking out of the courthouse, and at that point, I was thinking I can make maybe this into something positive again, and a vacation is always a good thing. You can start a new life, meet new people. I don't know.
You told them that you could get them a deal on vacation rentals.
Well,
Is
I
that right?
could get them a deal. That would help them out probably, especially since they just had their income cut in half.
So, I think I just heard you say that you wanted to make things light for them, which is why you handed out the card.
Correct, yes.
Well, you also seized upon this mediation to promote your real estate business to the participants, did you not?
Well, I viewed it as the mediation was over. Like I said, we'd left the mediation room, signed the agreement. We're all done here. I'm just walking in the hall with some people.
Now, you are aware that Mr. Murray is now attempting to have the mediated settlement agreement set aside, are you not?
Yes, he is.
Okay. I have no further questions.
All right, Mr. Billings, anything else?
No, Your Honor.
All right, so that will close the evidentiary and the testimony section of this. All right.
Now that the prosecution and the defense have completed their presentation of their cases, the hearing panel is going to deliberate, and that means they're going to have a discussion about the rules and the evidence they've heard and apply the clear and convincing evidence burden of proof. And so you're going to get to observe that. It also will be abbreviated, but you'll get a taste of what a deliberation is like.
Well, thanks everybody for being here. I know that some of you drove a long distance to be part of this panel, so we appreciate it. What I'd like to do is, there was 4 areas for which probable cause was found by another group, and we're here to determine whether there's clear and convincing evidence on these charges as it relates to the mediator. So what I'd like to do is start, Ms. Kim Mann, if you could take the first one, which concerns self-determination and coercion, and give us your thoughts.
Certainly. The self-determination rule 10.3, 10B and A specifically is about keeping the process available to the mediator to allow the parties to make the decision, not to have the mediator inject himself into the process. So that would be a violation of subsection A if the mediator injects himself. And then the coercion portion, subsection B, specifically prohibits a mediator not coercing or improperly influencing any party to make a decision or unwillingly participate in mediation. So what we have from the testimony is we have Mr. Murray indicating that it was initially scheduled for 3 hours and went 5 hours, that he specifically indicated that he did not want to continue with the mediation after the 3.5-hour mark, but was told that he would go to jail if the court found him in contempt of court for leaving early and not paying the additional fee. That right there seems to be rather coercive. And so if we believe Mr. Murray, then I do think that there is clear and convincing evidence for a violation of 10.310B.
All right.
Well, I agree. I think that the comment, if it was made by the mediator, is very inappropriate, and very coercive, and takes away from the participant's ability to make a self-determination. So I would agree with you.
I concur.
Yeah, and one of the things that I found interesting is when we went back to looking at the other sections of the testimony, we had the laughter from the other room, we had the not addressing Mr. Murray's concerns over going to the other issues that were not actually subject to the mediation. I think that those things kind of lend credibility to Mr. Murray's testimony. I mean, the mediator seemed to indicate that there was tension between Mr. Murray and his attorney, and yet the mediator specifically said he never even spoke to Mr. Murray about extending the mediation. So I think it would be advisable to maybe counsel the mediator on directly addressing the party about extending the mediation past the original time and not just relying upon communications with his attorney.
I agree with that. We need to present not just to the attorney, but to the actual parties.
Right.
I would agree with that recommendation as well.
So the term, "you will go to jail," should never be spoken by a mediator.
Absolutely.
Agreed.
Dangerous territory.
Very much agreed.
Ms. Perez, Vivian Perez, I'd like you to talk about charge 2. This is the conflict of interest and conflicts during mediation.
Thank you. The Rule 10.340D tells us that a mediator shall not create a conflict of interest during the mediation. During a mediator shall not provide any services that are not directly related to the mediation process. I believe from what we've heard, the undisputed facts to consider in this alleged violation are that at the conclusion of the mediation, the mediator, Mr. Short, gave the parties and their attorneys his realtor business card and then proceeded to offer them a great deal on a vacation package. You know, in thoughts here, the diverse backgrounds and expertise that mediators bring into our profession is a plus. Many persons who come into or join the mediation profession today do so as a secondary career and source of extra income. It is extremely important for these dual professionals to maintain a defining line between the two professions. Mediation is not an opportunity to advertise for new clients. I clearly believe we have a clear violation of this rule.
I see that as well, and I think that trying to define where the mediation ends, if the parties were there for that purpose only, and he took advantage of that after they had come to an agreement, they were still there for that purpose of mediation. Correct. And I think he might have overstepped the bounds there by using that as a way to promote his other practice of real estate.
Absolutely agree.
Agree.
I think I heard another panel once in one of these say that within the shadow of mediation, a mediator should never try to solicit or hand out business cards. And clearly they were still there at the building within the parking lot. So, all right, well, thank you very much. So, Ms. Valerie Lewis, I'd like for you to talk about the third basis that we're here, and that is demeanor.
Okay, that would be Rule 10.350, demeanor. A mediator shall be patient, dignified, and courteous during the mediation process. Now, although there are no committee notes to Rule 10.350, we can get guidance from other Rule Committee notes. Specifically, the committee notes for Rule 10.370 reads as follows. The primary role of the mediator is to facilitate a process which will provide the parties an opportunity to resolve all or part of a dispute by agreement if they choose to do so. Now you have to look at the relevant facts. What did we learn here today? We know that the mediator, William Short, allegedly was talking on his phone in the hallway, and the complainant, John Murray, overheard him say clearly, "I'll be home after I get rid of these eccentrics." The second relevant fact that we heard here today was that the complainant, Murray, heard the mediator through the caucus room walls laughing a lot with his ex-wife and her attorney. What we have is sworn statements under oath by the complainant as well as the mediator that was provided. The complainant, again, states that the mediator was rude and disrespectful, stating that I overheard him talking in his voice in the hallway, and I heard him say clearly, "I'll be home after I get rid of these eccentrics." He also said that it was obvious to him that the mediator was referring to him and his spouse. He said, "I could hear him laughing a lot with Lily and her attorney through the walls of the rooms we were in." He said he didn't laugh when he was in with me. Now, Mediator Short denies that, denies making the statement that he'll be home after he gets rid of these eccentrics. He denies even being rude and disrespectful. When you look at the sworn statements and the testimony that was given here today, we need to make a determination whether, in fact, Rule 10.350 was violated. It's my opinion, and of course we're here to deliberate, but it's my opinion that the mediator did not violate Rule 10.350, and I have several reasons for that thought. First, if you believe Mr. Short that he never made the comment and that he was never rude and disrespectful, you can't find that he violated the rule. Second, the mediator did not make the alleged comment in the presence of the parties. It was a comment the complainant overheard, and he can only speculate that the alleged comment was referring to him and his ex-wife. Third, if you want to be argumentative, you can argue that the alleged comment was not made during the mediation process. If, in fact, the alleged comment was made out of the presence of the parties and their respective counsel and during a break from mediation. And then fourth, if you look at Merriam-Webster's dictionary, which defines discourteous, it is defined as being rude or impolite, merely laughing with the other party through the caucus room walls without any additional specific facts which might mock the complainant is neither rude nor impolite. So my vote is that it was not a violation of 10.350.
I think on some of these occasions, you know, there's a certain amount of paranoia when you're in a room by yourself or with just your attorney and there's other things going on that you only, like you said, speculate about. And I don't think it rises to a clear and convincing stage as to what that actually might be or entail.
Well, and there was clearly tension in the caucus room between the complainant and his attorney.
To begin
and so it's not surprising that they weren't having a good time. So the fact that the mediator was laughing with the other party and her attorney doesn't speak to anything, I think. So, and again, overhearing that phone conversation, I agree, it's completely speculative as to what actually the mediator was talking about.
I don't think we have a finding on that.
Yeah, especially in light of the fact he had another meeting and he
Right.
could have been talking about the real estate parties.
You know, I agree with you on this one. Now, Mr. Short obviously can't hear us right now, but if he could, I'd say it was a family matter. There's tensions running. Don't be laughing unless everybody's laughing together.
Yeah.
So I would order 2 laps around the courthouse, but you can't do that. There was no clear and convincing. I think we all agree.
And this is coming from Jail Time Jordan.
Yes, thank you. Mr. Forrest Young, that'll be 3 laps around the courthouse. I'm going to let you do the last one, and that's fees and expenses.
Well, Rule 10.380 covers fees and expenses, and the importance of this rule is founded in the mediator's position of trust with the parties and the participants for mediation, along with establishing that the mediator's fees must be reasonable and consistent with the nature of the case involved. The rule expressly addresses a written explanation of fees. The rule states, quote, "A mediator shall give the parties or their counsel a written explanation of fees and costs prior to the mediation." So some of the highlights that I took from the testimony, In the direct testimony of the complainant, Mr. Murray, he stated that prior to the mediation, he did not receive any documentation or explanation from the mediator, Mr. Short. And actually, Mr. Short himself stated that he relied upon the order of the court only as to the notification to the parties as to fees. However, if we look at the order of referral to private mediation that was sent out by the court staff, it listed fees that were apparently customary for a court-ordered case in the amount of $200 per hour from each party for a total of $400 per each hour of mediation. But nothing further was stated in the court document as to potential costs or as to the length of the mediation time. So I think a mediator is obligated to alert the parties to these things.
Yes.
Yeah, that's clear.
I agree.
To me, that's a
Clear.
clear violation
Clear?
of the rule.
All right, so we all agree then that a court order is not enough, that the mediator is required by the rules to provide written explanations and fees and costs. And this is a perfect example of that.
Absolutely.
All right, thank you very much. Let's now go into discussing sanctions, which we've done off record. And for time's sake, I'm going to let you know what the panel would have decided, reduced to writing, and would have been sent out. So we would have deliberated, and we did find clear and convincing evidence of violation on charges 1, 2, and 4. And we did not find it clear and convincing evidence on charge 3, but obviously we would admonish Mr. Short to avoid laughing or otherwise allow parties to overhear you giving the impression that you are being discourteous. Now, the sanctions that the panel decided on are as follows: a written reprimand. Secondly, besides the normal CME requirements in your cycle, you will have to do 6 additional ethics CMEs, and they have to be pre-approved, and you will have to complete those within 6 months and provide proof of attendance. Third, you are going to be required to sit and observe 5 family mediation sessions conducted by a Florida Supreme Court certified family mediator that is pre-approved by the chief of ADR. You will not accept any fees for these 5 mediations that you're going to observe, and you must complete these within 6 months and file proof with the board. Fourth, those $2,000 in fees you collected, Mr. Short, you're going to remit all the fees from both parties for the violation that we found, and that's got to be done within 30 days, and you got to file proof with the board. And finally, we are awarding and imposing reasonable costs, which will be determined by the panel chair, and you will have to pay those within 30 days. And of course, you will be provided written explanation of those fees, and you can respond to those within 10 days after receipt.
Thank you, panel, for all of your hard work and your deliberations. So as we leave, we still have a few minutes because we did abbreviate everything so well, and everyone stuck to their time clock like we asked them to. How many of you would have found any violations? Maybe we could do a vote by hand. Would anyone have found a violation of Rule 10.310? Oh, yes, that's the self-determination rule. I guess I'm assuming you have your rules memorized, but maybe you don't. 10.310 is self-determination. Did anyone think that the mediator violated that? Okay. The other rules were 10.340, the conflict of interest with the business card. Did you agree with the panel? Okay. And how about the demeanor? Did you think he violated that, or did you agree with the panel that he did not? Some. Okay, you agree with the panel. All right. And how about on the fees? Did you agree that the mediator violated the rule regarding fees? Okay, so
So you think a court order provides you protection
You're mistaken.
No, I think they were voting that,
Yeah, the ones that didn't raise their hand, I was just
Oh,
pointing that
right.
out.
right, Judge Jordan was just saying the rule requires more than just whatever the information about fees was that was in the court order. We still needed a letter of engagement and fee explanation from the mediator. So if you have any questions about anything in the abbreviated hearing panel demonstration that we did today, we don't really have an opportunity to do that in such a large group, but if you would like to send them to the DRC email account, you are welcome to do that by September 1st. And we thought we
We'll get
could
Juan to
write an
answer.
article in our newsletter, The Neutral, answering any questions you may have. So if you do have any questions, be sure to contact us and we'd be happy to answer them. And otherwise, I just want to thank you for coming.